The Affordable Care Act, better known as Obamacare or the ACA, is once again before the United States Supreme Court. The justices will consider the constitutionality of the ACA's individual mandate provision. That's the part of the law requiring Americans to maintain a minimum level of health insurance coverage. In 2017, the government made the tax penalty $0, and that triggered another round of challenges to the ACA. A federal appeals court found the individual mandate unconstitutional, but did not decide whether the rest of the law can remain. Now, a group of 20 states, led by Texas, are seeking to have the entire ACA struck down. 17 states, led by California, are defending the ACA. The major question for the court, is the individual mandate unconstitutional? And if so, is it severable from the rest of the Affordable Care Act?
And Court TV anchor Julie Grant joins us. Julie, great to see you. All right, you're our in-house professor, so it's appropriate that you should be handling the Supreme Court stuff.
You're too kind.
Let's start with some of the legal issues. Who can sue? How do you get the ability, the standing to bring this case? Because that's always an issue in front of the Supreme Court and in front of any judge, whether or not you have even a right to bring it. So how does Texas or these other states get to bring this case?
Yeah, you're absolutely correct there. And that was the first big question. And the thing that's really tricky with standing, especially when it comes to a case that gets all the way up to the U.S. Supreme Court, if the standing issue isn't there, if there isn't the right to bring the legal challenge, then the court won't even get to the big questions of constitutionality that everybody really wants the answers to. So it's very, very critical to this case moving forward. And it was addressed, it was discussed, and to kind of give the Reader's Digest version to this argument. Essentially, when we're talking about either obtain health insurance or pay the tax, and then that tax becoming a $0 penalty, the argument that the respondents had put forth in Texas, they're saying, look, without a penalty for noncompliance, this order to obtain health insurance is a command from the government, and a command just isn't constitutional. And because we are paying money to have this coverage, we're out this money. This gives us standing to sue. So that was one of the arguments put forth. It was discussed, and as a matter of fact, Chief Justice John Roberts started out the questions with one on standing. So let's take a little bit of a listen to what he and Justice Clarence Thomas, had to say in the arguments.
Well, let's say Congress passes a law saying everybody has to mow their lawn once a week. And they even make a lot of findings about why that's a good thing. You know, it makes the country look neater. You get fresh air if you have to do that. Supports the lawnmower business. But the fine for violating it is $0. Do they have standing? I mean, the neighbors will see that they're not obeying the law. The objectives of Congress will not be fulfilled. In other words, there'll certainly be injury to that person, and I wonder if under your theory that person would not be able to challenge the law.
I don't think that they would be on the theory that they've altered their conduct to comply with the law and they've suffered some injury. I think that follows from this court's cases in Poe and Holder and American Booksellers, that it's not enough to say that I'm injured by complying with the law. You also have to show some real threat of enforcement. And here, of course, Congress eliminated the only enforcement mechanism in 5000A.
Thank you, General. Justice Thomas?
Thank you, Mr. Chief Justice. General Mongan, in putting it the Chief Justice's question in today's terms, I assume that in most places there is no penalty for wearing a face mask or a mask during COVID. But there is some degree of opprobrium if one does not wear it in certain settings. What if someone violates that command? Let's say it's in similar terms to the mandate here, but no penalty. Would they have standing to challenge the mandate to wear a mask?
Well, Your Honor, I think under this court's cases, the question comes down to whether there is a real threat of enforcement. If it's just a bare command, I don't see how that would be consistent with cases like Poe and Holder that have looked not just to the question of whether it's a command, but to whether there is a threat or possibility of enforcement.
Okay, so again, it's quite possible if the court doesn't find there is standing there, if the court feels there needs to have been an injury in order to bring this litigation, then we won't even get to the question of constitutionality. But of course, Vinny, they did in these arguments, and we heard a lot about it. Roughly 2 hours spent.
2 hours.
Oral arguments today before the court.
That's a lot. The question of standing, though, from what I've seen, traditionally, a lot of times the Supreme Court likes to just get rid of something without actually deciding it. But we'll see if they get to that this one. So let's talk about the constitutionality. And again, that is the ultimate big question here, right?
Right. So certainly this is the thing that everybody wants to know about. Is the individual mandate provision constitutional or not? And if it seems kind of like Groundhog Day, we were here once before. For those of you who remember, back in 2012, the case was NFIB versus Sebelius, went all the way up to the Supreme Court, the court upholding the individual mandate as unconstitutional. The ruling said that the required financial penalty to the IRS for those who didn't purchase that required coverage was a constitutional exercise of Congress's taxing power. So then what happened in 2017? What did Congress do? Well, they passed the Tax and Jobs Act, and the lawmakers set that penalty, or the shared responsibility payment as it's called, at $0. So then the problem then becomes leaving the remainder of the ACA in place. Congress didn't repeal that provision. They zeroed it out. This is where it gets really, really dicey, and why we have this second challenge. Well, if the government isn't making any revenue, is it really, in fact, a tax? So let's take a listen now to what some of Justice Amy Coney Barrett had to say in terms of questioning during the arguments. Let's listen.
What should we make of the fact that Congress didn't repeal the provision? I mean, you said earlier repeal, and then you corrected yourself and said zeroed out. I mean, you're asking us to treat it as if it functionally has been repealed, but that's not what Congress did. Does that matter?
Your Honor, I think Congress understood how this court had construed 5000A as a choice, and it understood that it would make the provision effectively inoperative to zero out the tax. And that was a reasonable thing for it to do. Obviously, it was operating under reconciliation procedures that allowed it to make the change compliant with the Byrd Rule. And CBO had told it that there was no material difference between repealing the provision and zeroing out the tax.
Let me ask you another question that's related to some of the hypotheticals you've heard so far. You know, the chief asked you about a mandate to mow the lawn, and Justice Thomas asked you one about forcing people to wear a mask. What if, in this case, and as I understand it to be the case, you have to certify whether you've complied or not, and then the government keeps track of that. So the government keeps track of whether you wore a mask or whether you purchased health insurance. Does that change your view of whether there's an injury?
Well, I'm not sure that there is an ongoing certification requirement, at least in the tax forms, Your Honor. Perhaps that would change the analysis. But if we get to the merits, then I think that it's plain that this is not an operative provision and there is no ongoing command. So even if that would establish standing, it wouldn't be enough to allow the individuals to prevail on the merits.
Vinny, as you know, everybody was so anxious to hear from Justice Amy Coney Barrett, and she had a lot of questions. We don't have time to share all of it, but that was just a little bit of what she hit on. And really the fact that zeroing out was key, not repealing it. So essentially, is the court being asked to do what the legislature should be doing here? We really got the sense today that the court's going to leave this alone. At least that's the way it seems. That's my reading of the transcript today and what we heard from them.
What's fascinating about the tax aspect of it is that last time, nobody argued that it was a tax. It was like Chief Justice Roberts kind of like picked it out of the air as a way to save it, which is that's the argument. Like, that's judicial activism, right? That is doing something to, all right, we think this is a good thing, so let's figure out a way to keep it. And what you're telling me now is it seems like they're going to try to do that again. because if the tax is zeroed out, it's no longer a tax. The only reason it was kept last time was because it was a tax. And now, obviously, if you don't pay anything, that's not a tax. I'd like to have that tax. If that's going to be a tax, give me that zero tax. And by the way, all the talking about mowing the lawn, I'd like the Chief Justice to know that it is mandated by my homeowners association that I mow the lawn. So maybe I should be suing them in Supreme Court. But anyway.
Maybe you have standing. Yeah,
I think I do have
Is there a threat
standing.
to you that you feel if you don't mow your lawn? Yeah.
Exactly.
Right.
So let's get to severability, because
Right.
that may be, again, the way to keep this patient alive, right? Is we just cut this little tumor out of Obamacare to try to save it. So how did that go?
Exactly. So the second question, if it's answered, let's just say they find the provision unconstitutional. Let's say they say this is a command, it's not a tax. Government can't do that. Okay, so then can the rest of the ACA survive? That's what many Americans want to know. And we had a little bit of a hint from Justice Brett Kavanaugh that the court may be inclined to just go by the rule of severability and just say that that provision is struck down and not the entire ACA. Let's take a listen to the justice now.
Then on severability, if the mandate can't be justified or the mandate is currently structured, I'm using the term mandate. I understand the arguments from the other side about that term, but the mandate is currently structured, can't be justified under the commerce or taxing or necessary and proper clauses. We get to severability. And looking at our severability precedents, it does seem fairly clear that the proper remedy would be to sever the mandate provision and leave the rest of the act in place, the provisions regarding pre-existing conditions and the rest. So the question to you, obviously, is how do you get around those precedents on severability, which seem on point here?
Justice Kavanaugh, I get around them by relying on the text of the statute. AAPC, Your Honor's plurality opinion for the court, recognized that non-severability clauses can be statements of congressional intent. And as I noted earlier, the Obama administration's Department of Justice referred to 18091 as a functional inseverability clause. In that statute, we've got multiple instances of Congress insisting.
I'm sorry to interrupt, but inseverability clauses usually are very clear, and we did indicate what they look like in AAPC, and we cited an example of what they look like. And, you know, Congress knows how to write an inseverability clause, and that is not the language that they chose here. So I agree with you about focusing on the text, very much agree with that, but I just having trouble seeing that as the equivalent of an inseverability clause.
Justice Kavanaugh, we would respectfully submit that that would elevate form over substance. In subpart H, we see the mandate as essential to the larger regulation of economic activity. In subsection I, it's essential to creating effective health insurance markets. And the same thing again in subsection J. This is Congress saying over and over again that the mandate is essential to the operation of the law. And I don't believe there's any serious argument that Congress would have enacted the ACA in 2010 but for the individual mandate or without the individual mandate.
So the respondents, Texas, of course, saying that this provision, it's unconstitutional, and as such, the whole entire ACA should fail. That is their argument. Of course, the California petitioners want to save the ACA, and it's always risky to make a prediction about how the Supreme Court's going to rule. But just looking at some of the arguments, it seems like there was some inclination to leave things intact, or if anything is deemed unconstitutional, maybe the individual mandate. But as we just heard Justice Kavanaugh saying, it seems like the court may be inclined to just sever that provision and leave the rest of the ACA intact. And a decision sometime next year, Vinny. So we won't know for a while what's going to happen with the ACA, but sometime next year we'll get the court's ruling.
Okay, so we will wait for that decision. I'm going to predict a 6-3 that it gets severed. And what's your prediction? You got a prediction?
Yeah, you know, I know that's probably yeah. I think if you're right on that one, It seems that way. It does. I'm gonna think Justice Roberts probably would go that way as well. And so yeah, I'm with you on that one, my friend. Let's
right.
say 6-3. We'll see. Maybe we'll be wrong. I don't know, but it does seem like if they were to deem it a command and say that it's unconstitutional, that severability might be just a way to split the baby and just let Congress do what they do and figure out a better way to construct that individual mandate if there is a better way for them to do it.
You want Congress to actually do their job? You don't want the Supreme Court to do it for them? Because that would be wonderful. Everyone does
right?
what each branch of government is supposed to do. We wouldn't have these problems. Julie Grant, thank you so much. Appreciate it.
Thank you, Vinny.